Good morning. I hope everyone had a good weekend, although it was quite cold, surprisingly cold. We have 3 cases on the docket this morning. 2 are set for argument. The first case we have is In Re D Children, and that has submitted on the briefs. That's case number C210618. And then we have case number C220138, State of Ohio versus Stanford. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Hal Aristide on behalf of the state.
Good morning.
Labs, we have the state ready to proceed.
Good morning. And then the third and last case we have is case number C220176, State of Ohio versus Gibson.
Good morning, Krista Houston on behalf of Ohio Gibson, ready to proceed.
Good morning.
Judy Lapp for the state, ready to proceed.
Good morning. Alrighty. Attorney Ehrenstein? Would you like to reserve time? Good morning.
May it please the court, if necessary, I'd like to reserve 2 minutes for rebuttal.
2 minutes. Whenever you're ready.
Thank you. This case, I think, should be controlled by past precedent, both by the United States Supreme Court and by our various courts in Ohio. This particular incident involved a stop for what was apparently an insignificant equipment violation. After the stop, there was some information that suggested this car might have matched the description of the vehicle that had been involved in a shooting a week or so previous.
Did that occur before or after the stop?
Before, Your Honor.
Okay.
About a week before.
No, with regard to the officer's
I don't think the
concern that it
officers-
might be tied to this shooting.
I don't think the initial officer who made the stop had the knowledge that this car somewhat matched the description. He stopped the vehicle for an equipment violation. Once the information went out over the dispatch, I think one of the other officers who was involved in the violent crime department said, well, you know what, that car sounds like it might match a car that we had in a felonious assault a week or
But I
so
thought
ago."
they approached the car with guns drawn and
Well, they did that eventually.
so they must have suspected that it was
It's
they wouldn't do
unclear.
that for an equipment violation.
It's unclear from the record as to the chronology of how that occurred, but they did approach the car, they did order him out. He complied, was placed in handcuffs, was immediately seized and placed in the back of a cruiser. One of the officers initially thought maybe he'd seen something thrown from the vehicle. A dog was called to the scene. The dog went over an entire area on the side of a hill, didn't find anything, and eventually that particular officer said, you know what, I'm not really sure I saw something tossed from the car. So that kind of went by the wayside. So what you have here is the clock is ticking. My client has stopped, and within 21 minutes, there's a decision made. We're going to try and contact the officers who were involved in this particular felonious assault. The only issue here, or the only specific fact that would give rise to a reasonable suspicion for them to continue to hold him, is the fact that the car matched the car. They didn't have a license plate. They didn't know whether the driver of the car was white, African American, or brown. They didn't know if the driver of the car was old. They didn't know if the driver of the car was young. They had no description of the individual who had been allegedly driving this particular car.
But even with that, if the car matches and there was some testimony that it was a unique color on that type of car, is that enough to prolong the stop to investigate, to determine if indeed they believe that that car was actually the one involved in the shooting?
Not for 21 minutes, Your Honor. I think if they had other information that would suggest that, yes, maybe. But what's interesting is they filled out what's called, what used to be called a field information report. So they knew who Mr. Stanford was. They had his identification. They had the license plate for the car. So they had the information on who the driver of the car was, and they had the information on the car itself. So to continue to hold him for 21 minutes doesn't make any sense. They could have let him go. They could have continued with the investigation later. They could have reached back out because they knew where he was to find
But
him.
wouldn't they want to make sure this guy was not involved in the shooting before they let him go?
But this became a drug case
Right.
out of a hunch.
No,
That's all.
I understand
Okay?
that. I understand that.
Okay. If they had more information, look, if there were bullet holes in the side of the car, okay, I get that. But just because a car might match a car that, color-wise might have been somewhat unusual doesn't necessarily, he's proceeding on a hunch. And he candidly stated at one point, I didn't care whether I had probable cause or not, I was going to search that car. So to suddenly decide that, you're going to put the dog around the car 21 minutes after he's been detained, what are you looking for? There's no testimony that this particular dog was trained for the purpose of looking for firearms. There's no particular information that suggests that even though GSR is somewhat suspected these days, there's no indication that the dog was able to alert on that. The only reason to put the dog around the car would be for a drug investigation. So why suddenly do we go from a felonious assault to a drug investigation after 21 minutes? It doesn't make any sense.
Let me ask you, Mr. Anderson, do you raise the issue about the dog at the trial court? Questioning whether the dog was trained in gunshot residue,
Never
drugs?
came up. It's not on the record.
And the only other thing, I think we've all watched that
Video? Yeah.
body-worn camera, and there was an overwhelming police presence
Absolutely.
there. And when I viewed it, it looked like the dog was there contemporaneously or right after the stop. It wasn't like we waited 21 minutes
That's
and
correct.
then
That's
called
correct.
a dog. The dog was running up and down the hill looking for something or other, but
Well, you could have run the dog immediately around the car. Why do you have to wait 21 minutes? Why do you have to detain somebody when you don't have any other information other than, well, yeah, this car kind of looks like the car that we were looking for?
well, the officers thought the testimony was they thought they saw something interesting thrown from the car, that at least they were interested in trying to find it when they ran the dog up and down the hill.
So if he was driving a Volkswagen that was maybe a 1962 Volkswagen, I mean, they're going to detain him for 21 minutes because it's an unusual car. If he had made some admissions, if they had asked him, are there any firearms in the car, are there any drugs in the car, is there anything I need to be concerned about with my safety if I'm going to go into the car, that would be one thing. When you look at, for instance, if you look at the Wood case, which came out last summer out of Licking County, which is a fond county of mine because I went to Denison, which is the next county over. That case was only 4 minutes. And in that particular case, they found that they improperly prolonged the detention for only 4 minutes. Here, it's 21 minutes. And again, if they had more information, if the detectives had shown up, and ironically, he was never charged with anything with respect to the felonious assault. No firearms were found in the vehicle. The only thing that was found in the vehicle was the cocaine. And it was nothing to suggest that he had done anything illegal prior to this equipment stop.
So when you say if they had had more information, I thought they were trying to get more information. And so I'm trying to reconcile what you're saying with what they were doing.
Well, think about it. I mean, they're always trying to get more information. The investigation continues, but within a 21-minute span, in what has been constitutionally determined to be an improper extension of the detention, they just didn't have any more information. But what they did have is they knew who he was, and they knew how to read. They knew the car. They knew the license plate at that point. If they wanted to continue with the investigation, they could have done that at a later date. But to continue to hold him in hopes that they're going to find something else, I think is improper. If there was anything else that they had learned, any other articulable, reasonable suspicion that they learned, then I think they could have continued with the detention. But to hold him for 21 minutes and then just say, well, we're going to run the dog around the car. If everything's okay, we're going to let you go. All right? And at that point, it's a hunch. It's nothing more. It's not even a hunch based upon a reasonable, articulable suspicion at that point. So.
I just want to ask for clarification. So do you object to the 21 minutes, or is there a pause in those 21 minutes that you also object to?
I think once they placed him in detention at that point, rather than having him sit on the sidewalk, which is pretty typical, just have a seat right here, we'll get back to you. But I think once they placed him in detention, I think the standard went up at that point. But based upon the case law that I've read, it's still a reasonable, articulable suspicion. I think there was nothing between the initial stop, I can't remember the exact time, maybe 4:04 until 4:25 when they actually did the stop. There was nothing within that period of time. In fact, if anything, the fact that the other officer said, I didn't see anything come out of the car, would suggest that there's no further reason to even continue to hold him. Does that answer your question? Any more questions? Judge?
No?
All right, thank
I'll
you.
reserve the remainder of your time.
Good morning, Your Honors. May it please the court. Mr. Ernstein, I'm sorry I woke up with this voice this morning, so
I'm sure has
My
nothing to do with
apologies.
the fluctuation of the temperature.
Yes. I think, first off, I'd like to just emphasize that this court has the advantage of being able to view that body cam. And I think all of that will reveal that this was not an illegally prolonged stop or pause for the drug dog to make the walk around. And just, I mean, pardon the analogy during basketball season, but, you know, the police aren't operating on a shot clock here, okay? It's a fluid matter. One officer thinks that maybe he saw something thrown from the car. They have a drug dog, then you know, things are coming in simultaneously, and they're trying to do the best they can out there in the field under the circumstances. So I think to just across the board say, well, it was 21 minutes, that was way too long. I don't think you can do that in this case.
Yeah, let me ask you this. So I think what they're complaining about is there wasn't anything actually tying him to the shooting. And so the officers were kind of calling around to see if they knew any more information. And I guess at some level, how long is it appropriate to sit around and wait for potential information that might or might not connect him to a shooting? I mean, obviously, it's one thing if this guy is a suspect, but we don't know that.
Right.
And they're calling around, they're trying to find out information, but like how long is it appropriate to wait for that?
Well, and I think the circumstances, particular circumstances in this case, is the police officer testified, he was concerned, he didn't know if he was potentially dealing with a crime scene. This was two cars involved in shooting at one another. So I think that is a big distinction between some of these other cases when it's not just the suspect, it's what he's in could be a crime scene. And there was also testimony with regard to the dog, obviously, that appears to have been in response to whether or not something was thrown from the vehicle. But then there became some concern. They didn't want the dog, once they got the dog near the car, they didn't want the dog jumping into the car. And the windows were down, so they had to take effort to protect that again, which is indicative of they don't know if they're dealing with a crime scene here. So I think the circumstances under this case, dealing with, you know, everything that the officers are trying to look into at the
But to
matter, this was
appellant-
not prolonged.
But to appellant's point, if there wasn't any gun-related damage to the outside of the car,
Again, we don't know the circumstances. We don't know if, and there was some other, when they were talking about the other party, we don't know if, you know, the car that they had stopped. I mean, they have very limited information. Obviously, they don't want to just let this potential crime scene drive away. And then, you know, again, regardless of whether he was a suspect in that, this could have been, you know, a situation where this particular car was the shooter. Maybe there's shell casings inside. There can be gunshot. I mean, any number of things that they can't be expected to, within, you know, that 21-minute span, be able to solve all of that. That's why they're trying to get a hold of the investigators.
so absent any delay that is more than what's required for whatever's at hand, what is required in order to do a dog sniff around the vehicle?
What's required? I don't understand. Well, I think under these circumstances, we had, you know, to me, in reading the transcript, I think the purpose of the dog originally was looking where maybe perhaps the officer thought he saw something.
And that's different. That's the hillside search.
Correct.
But I'm talking about the ultimate search.
Right, and the timing of that, again, I don't know how long exactly the dog on the hillside took, but not finding anything there, certainly it's reasonable then, I mean, the dog's already there, have him walk around the car. I mean, the officer said, oh, well, maybe I didn't see, you know, I thought I did, maybe I didn't. So then at that point, the dog's going around the car, and I certainly don't think that was prolonged, given the circumstances, all of the circumstances that were involved with the stop.
Let me ask you, Ms. Adams, just assume there was no canine available on the day in question. Can you justify the search of the vehicle under Terry?
If the
There's no
dog had
dog,
not-
they call, the dog's not available. knowing what the police had in their head at the time, did they have a reasonable articulate
Yeah, quite
suspicion?
possibly. And again, you know, they were certainly, the best case scenario is let's get a hold of the investigator. Maybe, you know, we don't know. Are we looking for, is this unique car supposed to be all shot up? We don't know. Is this the car that the shots were coming from? So I think it's reasonable that the officers were at first taking that step before going on and you know, searching the car. But certainly, I think based on the information they had, they could have.
Well, and the reason I ask that is that at some point during the video, it was the sergeant, I think the officers were ready to search the car before the dog, and there was a suggestion that they wanted another layer of probable cause, which indicates to me that they thought they had probable cause to search without the dog.
Quite possibly, yeah. I mean, and that's reasonable. You know, and again, there's multiple officers there, and I had trouble, what limited ability I was able to watch the body cam. It wasn't clear to me. Mine kept fading in and out, so you're probably heads and tails above me if you were able to get the whole.
What was the initial basis of the stop?
I'm sorry.
What was the initial basis of the stop?
All I've heard described as an equipment violation, but he never challenged the legality of the stop. That's not an issue here. That wasn't an issue in the motion.
Okay.
He conceded the legality of the stop. Unless there's any further questions, I will be quiet now. Thank you.
Thank you.
To answer Judge Winkler's question.
So you have 6 minutes.
6 minutes, wow,
I reserve the remainder of your time.
very kind. To answer Judge Winkler's question, I can't conceive of how they would have had probable cause to search the car at that point. They certainly, I think they barely had articulable facts and circumstances to continue with the detention. I don't know that there would have been any more. Now, if they'd have found something on the side of the hill, I would think clearly they would have had probable cause to search the car. With respect to your question, I think a free, an air-free sniff by a dog they don't require probable cause to do that. The question here is how long they detained. And in listening to the prosecutor, I hear all these.
So it all comes down to
Timing.
really looking at those 21 minutes
Correct.
and seeing whether there was a reason for,
Continue the detention.
exactly, for every minute of the 21 minutes.
And what I'm hearing from Ms. Adams is, well, they didn't know what they had limited information, it could have been this, it could have been that, and that's just, to me, they're just going on a hunch. If they're going on a hunch, that's just simply not sufficient for them to have held him for 21 minutes, particularly when they knew who he was, and they could always reach back out to him if they obtained any more information in their investigation. He wasn't going anywhere. He's a Cincinnati resident, and they would have certainly been able to find him. And even if they'd have made the arrest, the investigation wouldn't have stopped at that point. You would hope they would have continued with the investigation.
So the bottom line, your position is that because the car seemed to match a car that was involved in a incident that had occurred, that was not enough,
Correct.
that was just a hunch.
Correct. Judge Bergeron, you look like somewhat quizzical there.
I was just, I was wondering if she had a follow-up question.
I
so-
agree. So, well, thank you. It's the first time I've been here in a long time.
Thank you.
Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon.
I still have 4 minutes.
Use it over in the trial court.
It's going to carry over. We'll save it for your next time. How's that? You'll just have to come back. Good morning.
Good morning.
Would you like to reserve time?
I would like to reserve 3 minutes, please.
All right.
Thank you. May it please the court, Ms. Lapp? There are a lot of serious issues in this case, and I would like to focus on the grand jury issues. So in our first assignment of error, we maintain that the trial court erred in failing to order disclosure of Mr. Castile's pretrial statement. And really, this is a rather straightforward issue. We maintain that this sworn statement, which happened to be recorded in the grand jury room, was not grand jury testimony entitled to the secrecy afforded official grand jury proceedings. So as background, briefly, the accused have the right under due process to a meaningful opportunity to present a complete defense. And in line with this, Criminal Rule 16b7 affords defendants a right of access to all material witness statements. So at a May 2021 pretrial hearing, defense counsel moved for disclosure of what he at the time believed to be grand jury transcripts for an initial presentation of the case in 2016. And the reason he believed this is because this case, despite the indictment issuing in 2019, had a B16 case number, which is unusual. So at the time, the prosecutor insisted the case was not presented to the grand jury until 2019. So fast forward to 8 months later at trial, on the third day of trial, when the detective is testifying that Castile appeared before the grand jury in December of 2016. And that caused defense counsel to think back and protest that he had asked for those transcripts and been told that the case did not go before the grand jury in 2016. So at that time,
So can you address the preservation point on this and the
Sure.
difference between Rule 16 and Rule 6?
Yeah. So counsel, grounded his argument in the information he had at the time, which everyone was calling it grand jury testimony at the time. That is governed by Rule 6. So that is the basis on which the arguments unfolded, admittedly. We maintain that that does not counsel in favor of forfeiture because, for one, counsel shouldn't be penalized for, he had to figure this out. He had to suss this out bit by bit. Also, forfeiture is reserved for arguments that the trial court never got a chance to address in the first instance. And the general issue of disclosure of Castile's statement was discussed at length at many points throughout. So the overarching umbrella of disclosure of this statement was something passed upon repeatedly by the trial court. If that basis alone is not sufficient, we cited, I believe, case law in the brief that this court is empowered to consider any issue implicit in another issue. So again, the overall disclosure issue was well preserved. And then alternatively, if you aren't comfortable with that, the plain error standard. And that would be a deviation from a rule. The rule is Crim Rule 16b7. And then affecting the outcome of trial, and that's where we discuss, because of the dearth of evidence in favor of guilt, if you excise Castile's statement, you have even less to go by. So on those various bases laid out in the brief, we would argue that forfeiture is not appropriate to resort to. So defense counsel had asked for this statement, and when it was re-raised at trial, the prosecution insisted the case was not presented, and the direct quote, I believe, is, "It's a statement taken." Okay. So we maintain that, and I don't know, I tried to research this. This, I believe, is an issue of first impression. We maintain that using the grand jury room in such a way is not permitted by Criminal Rule 6 or Revised Code Chapter, I think it's 2969, I might do the wrong thing, but the grand jury is a creature of statute and rule. And if you read those closely, this procedure for using the grand jury room just to get a statement from a witness under oath with the grand jury, it's not to be considered by the grand jury in any way. That was actually emphasized by the prosecution below. We maintain that puts it on par with any other material witness statement that is discoverable and that the state must turn over under 16b7.
Let me ask you, Ms. Gieseke, the statement of Castillo, as far as you know, or as far as we know, was not read to the grand jury whenever that was convened in whatever year. I mean, is that in the record?
In
that,
16?
Yes.
Yeah, it doesn't sound like it was meant to be considered by them in any way. So I don't believe, it sounds like they were just in the room, over in the jury box, there. But they were never meant to actually, consider it, vote on it. It wasn't part of their investigation in their official capacity, nothing like that.
Because, and I don't know if it's in the record or not, but my understanding of sometimes grand juries just consider the police officer coming in and reading a 527 to the grand jury. So my question is there any evidence that Castillo's statement was read to the jury, or the grand jury, once it was ultimately convened. Does that make sense?
It does, and it was,
And do you know, or
if
can
any,
you tell?
we don't know for sure, but if anything, the prosecutor's insistence that they were just in the room, suggests to me that it wasn't read to them, that they were just in the room.
And in your statement to Judge Winkler a moment ago about like all of these things, like how do we know any of that? I mean, are these just dots you're connecting on like, oh, they were just there, but they weren't like engaged in the investigation?
Per what the prosecutor had said when this was being sussed out on sidebars and pretrial hearings, because it came up a number of times. So if you look at those times, if you connect the dots through those and the prosecutor's actual assertions of it's just a statement taken, I don't think I even have to extrapolate. I think it's in there from what the prosecutor said.
Okay.
So we maintain that the reason that this is such a big deal, if you look at this is a huge record in this case, right? 5,000-page transcript, hundreds of exhibits. I don't know how many evidence envelopes with pieces of bullet and jacket. None of that implicates my client. Absolutely none. There's no direct evidence of his involvement. All we have are the word of these three men, the co-defendant facing the exact same charges. We have Castile, who's the co-defendant's best friend, and then we have Kenny Gunn, who is the father of the deceased and related to the co-defendant. That's all we have. And that's why this is so important, because the statement of Castile and later Gunn, these two components, if you excise those two witnesses, all we have is the co-defendant's statement, who has a very big vested interest in the outcome of Mr. Gibson's case.
But wait, why would we excise their?
When you do the harmless error analysis,
okay.
that's the second prong. So you say, with the remaining evidence, if we knock those out, is there enough to convict? And we
But you're
maintain-
not saying that these witnesses should have been excluded, are you?
So Castile, you've got, it's a discovery violation, so you have the ladder of sanctions, right? So that would have been within the discretion of the court, if properly analyzed, to do as they want to. And the court could have, continued trial and allowed disclosure of that statement before it went on. There's a lot of things the court could have done. Gunn, and that's more with the next assignment of error, but I can get into his statement. I think his is a little more egregious, and here's why. I'll go ahead and skip ahead a little bit. So Kenny Gunn's, during his trial testimony, he kind of slipped and started to testify that my client, 2 months after the shooting, confessed, basically, apologized for the shooting of his daughter in front of a library in Cincinnati. And the reason counsel objected and said, I did not hear, that, clearly a statement against interest is a discoverable statement pre-trial, and counsel said, I didn't hear about this. And the prosecutor said, well, if a statement's made in such a way that's not disclosable, it's not disclosable, and never mind, a move to strike, they struck it from the record, that's fine. But counsel pondered it overnight and thought, what could have made them think that wasn't discoverable? Oh, grand jury. So, and the state, the next day, counsel came in and said, move for disclosure of that grand jury testimony. Here's why. Here's the particularized need. My client was locked up during that time, the few months surrounding that alleged confession. He couldn't have happened. So he said, no, this disturbs, and that is my overarching point with Kenny Gunn, is that means, and the state never said, no, that's not, the state kind of conceded by silence. It was grand jury, it was grand jury testimony, it wasn't discoverable. But that, if he said that in front of the grand jury, that disturbs the entire foundation upon these very serious, life tail murder charges against my client. And for the grand jury to hear that my client basically confessed, that is an egregious false statement to be made. So
Let me ask you, the trial court was aware of that was a false statement?
the court was, and the problem with the court's analysis, though, is, it was a bench trial. And the court said, but that false confession was excised from the record, so disclosure denied. And the thing is that excising it from consideration for guilt is not the same as counsel in the due process sense having, for one, questioning the foundation of the charges, but two, having access to that alleged confession pre-trial before this ever happened, before counsel ever prepared its defense. So we maintain that rationale is faulty, that just because it was stricken from the record, it doesn't cure the error.
And that's because you believe it would have been in impeachment material at trial, right?
More than that. So, and that's a nuance I would love to
How is it
explore.
more than that?
So, yeah, so actually for both Castile and Gunn, and this is something I think the state's brief respectfully doesn't quite suss out the nuance or respond to our nuance, is impeachment. Impeachment in the sense of Castile and Gunn are liars. That is not allowed. That is not enough of a particularized need, and that's not all that we're saying. For Castile more so than Gunn, but the motive to fabricate. Each of these men had their own ongoing felony criminal prosecutions at the time. And Castile's, we do know the timing of his deal getting out of River City in the beginning of a 6-month stint, right after he gave his statement. That's at least enough to, that's not the standard for his anyway, because we maintain it's not grand jury testimony. But for Gunn, that fake confession from the library, that couldn't have happened. More so than impeachment, like we said, it disturbing the foundation of the charges. It's particularized because, unlike a lot of grand jury stuff, we know exactly what he said. It was that fake confession. And then the need for it really would stem from this overarching lack of evidence in favor of my client's guilt in this huge record. Pretty much nothing but the word of these 3 men implicates him.
But there were so many other bases to impeach Gunn that were ably utilized by defense counsel at trial. Like, I realize this would be something else, but like, how does that give the defense a material disadvantage given what they already had?
And again, and I'm not sure if the Greer or the Seminole case is what addressed this off the top of my head, but this motive to fabricate, Kenny Gunn was brought up on his own charges, felony drug charges, a week after his daughter was shot. So, and there was there's just a lot of weird, I think we don't have a lot of the picture on some of this stuff. This drug task force coming in and bringing him into Blackwell, I think it was Detective Blackwell at the time, saying, hey, he's got something to say to you. And then the way this unfolded, that was part of, in connection with his drug case. So he was already on the hook. We maintain he was already looking to get out of his own multitude of criminal charges. And this motive to fabricate, again, that's separate from saying someone is in a pure impeachment. Motive to fabricate, he had a reason in this case to make up this story in order to implicate my client to get leniency in his own case. That is a separate thing from just pure impeachment.
But, Ms. Gieske, my understanding was the trial court was aware of any case consideration these 3 men received. I don't want to say in exchange for their testimony, but the court was aware that there was maybe some case consideration to ensure their testimony. I mean, am I correct or not incorrect in that?
The court, it was brought up on cross.
Yeah.
Yes, it was. It was, but again, the problem is that this was entirely a credibility case, and if you look at these 3 men, they're not highly credible witnesses to begin with. So in a case, again, where it's very serious, very little, no direct evidence, credibility was just too important to not, at least, at the bare minimum, and I believe it's our 3rd assignment of error, conduct an in-camera review. So that was where the trial court, we maintain, should have at least taken those grand jury materials, Castile's statement, Gunn's testimony, gone in chambers, looked at it herself, and declined to do so. And that's fine. If she doesn't want to do that, then the next step on our ladder of arguments is proffer. And that is the 4th, I believe, no, that's the 3rd assignment of error, where the proffers should be freely granted and was not granted in this case. So at a bare minimum, we maintain this case should go back to allow that proffer, or if this court prefers, to allow the trial court to take that look in the first instance in camera. Whatever this court would want to do, a limited remand would work as well.
Thank you for your argument.
Okay, thank you.
May it please the court. Good morning, Your Honors.
Good morning.
I had several points I wanted to make. First of all, this idea that there's a distinction between an investigative grand jury and an indicting grand jury. The criminal rules make no distinction between the two. And there are many, many times their testimony is put before a grand jury before the indictment. This case, it took 3 years to get to the point of an indictment.
Yeah, and I guess the defense position is that this was kind of a ruse, that this was done simply to preserve testimony and to exclude it from.
That is what they said.
And so my question is, what is the state's best argument as to the propriety of that?
The reality of what goes on with these cases, the calling it a ruse was mostly, I think, in the appellate brief. You have investigative juries with complex cases, civil and criminal. You have cases, say, a grand jury is investigating a police department. There was a big case in Detroit. That was investigative. I looked in other states. The most I could find was Connecticut. And they say there is no distinction between the two. And they are both legitimate. And that recognizes the need to encourage cooperation that underlies the expectation that the grand jury will operate in secrecy. Here you have almost every case I have with a murder. It involves the people who often are witnessing murders are people who have been around the people who are committing the crimes, and almost everybody does have a record. And they do have drug convictions. They often have pending charges. That has made it so difficult to get witnesses in Hamilton County because they're afraid of retribution. And is not to beat a dead horse, people have been killed.
But what about the point that the prosecutor was, intentional or not, saying that this didn't go in front of the grand jury until 2019, and actually this was happening in 2016?
Yes, and in 2016, the prosecutor had nothing to do with the case. So my impression was when Detective Weatherall was testifying and brought this up, I think that was news to the prosecutor. And that's why he said, oh, when I was asked, I said, no, there was no presentation to the grand jury, and he's meaning for an indictment. And then it came up that it was the use to preserve testimony. And there's absolutely nothing in case law, nothing in the rules that says this is improper. And to say it was a way of the judge colluding to prevent a statement and the state doing it on purpose in secrecy to stop having to give up a statement in discovery, it's just not in there at all.
Well, but you appreciate the distinction between if you took a statement from a witness that was not covered by the grand jury, you would have to disclose that, whereas if you put them before the grand jury.
And that, my point is, Criminal Rule 16 could have done that. They specifically said if there's a co-defendant who testifies, that grand jury transcript is given to the defense. And they could have said any witness, all witnesses. They did not. They specifically said witness testimony is, in front of a grand jury is not discoverable. And under the defense's theory, when you look at this, every witness who testifies, they would then be able to get the grand jury testimony, because they're saying that when there's a perceived inconsistency, it becomes a particularized need. You're not going to have anyone, lay witnesses who have no criminal backgrounds, that there's almost always some inconsistency, however small, that maybe because of memory, like here, it took 3 years for this case to come forward. Excuse me. I have this whole COVID thing. I think it's left over. And then you look at the defense counsel's statement in this. He said if he had the testimony of Castile, he could cross-examine him about the transcript on top of what I already have. And then he says in his main argument, there's no such thing as too much impeachment. At all times, they're arguing impeachment. And the standard is, it's up to the discretion of the trial court to release grand jury transcripts, but the defense must prove to the satisfaction of court there's a particularized need.
And so can can the defense ever satisfy that standard in the state's view for impeachment purposes?
For impeachment, no.
So
Particularly,
they could never satisfy,
the case law, Supreme Court, everything says that. Impeachment alone is not enough. I tried to find cases where transcripts were released. And there's one, I thought it was mentioned in Greer, but I could be wrong, where a woman, when she was testifying, said she admitted out in the open, this is not what I testified to at the grand jury. It was a completely different story. And there was another case where all through the indictment period, a woman had said she was raped anally. And then they get to court and she's testifying, and suddenly she switched it and said it was vaginally. Those were thought to be so egregious, and that was brought out. It was more than impeachment, because it would go back to the basis of the indictment. Particularized need
well
was
then,
found.
but then that goes, then you fall right into the gun example, because that's what they're saying about gun, that it's not just an inconsistent story, but the very foundation for the indictment was this notion that he got this apology.
But he was not, and I wanted to say something about that, that it was very quick, and all he got out was to say, he said, I'm sorry, which could have been taken many ways, but immediately there was an objection, and immediately it was struck from the record. That was something completely aside, and the judge said, I'm striking it from the record, and I can put that out of my head that I did not hear that, or that did not occur. And I don't see that as any more closer to particularized need.
Well, but I think there's a difference between the admissibility of that statement and then the foundational need for the defense to basically unravel the basis for the indictment if this guy made up this story about this apology that didn't exist. I mean, that's what the defense is saying here.
Yes, but that wouldn't go back to unraveling indictment. I mean, Kenny Gunn's testimony was only for saying where he said he saw Gibson after the shooting, and he said he saw Gibson back at the area where everyone congregated.
Right, but if he came into the grand jury and said, let me tell you why I know this guy was the killer, because he came and apologized to me. And if that's false, like that's significant, right?
But if you read the transcript, I don't think it was a confession. It was saying, all he got out was, I'm sorry, which could have meant, I'm sorry for your daughter to have died. It's putting a whole different twist on it. I just think that in this case, everything that was asked about was for impeachment purposes. That's what was argued below and argued by defense counsel, and that ignores the secrecy of the grand jury. One other point on Castile. Twice, the judge said, if you want to recall him, you can, and if you want to reopen your cross-examination. And both times, defense counsel said no. So that kind of, he said, I'll just argue it in closing. And he did. So, but that goes to show that it was, his argument that it really was only for impeachment purposes. Those are my main points.
Thank you.
All right.
How much time do I have left, Judge?
3 minutes.
Okay. So just a couple of points. So I've never been a prosecutor, so I had to teach myself the grand jury stuff. It is difficult when you try to compare to other states, because I found there's a wide variance in how the states treat grand jury. And then there's a big difference between federal and state. I think actually under federal, this would have been clearly disclosable, but that's not binding. So I looked at length, tried to look into this investigative versus presentment grand jury or indicting grand jury. And it looks like when the grand jury is using their investigative powers, number one, they issue a subpoena for that witness, which doesn't look like that was done here, and it would have been improper. And here's the reason. The case law that I found, and I don't think it was Ohio, but it is unanimous that a grand jury cannot be invoked to further the police investigation. That oftentimes there is a parallel police investigation going on sometimes when the grand jury is looking into something, but the state cannot cross those over. The state can't invoke the grand jury to look into its own investigation. The grand jury can use its subpoena power to bring in someone, but again, by the prosecutor's repeated admissions, the grand jury wasn't involved here when Castile came in and gave his statement under oath in the grand jury room. It was just a statement taken. So one point that I just really wanted to make is we never use the word, the judge colluding, trial judge, no way. Just want to make that clear. I'm not denigrating the trial judge at all. I think we use the word sanctioning it, and I just meant that in the respect of denying disclosure and allowing this process.
Well, and just getting back to the state's response here, so they say that investigatory is fine, a perfectly permissible use of the grand jury. I hear what you're saying about what other states are saying, but where in Ohio could we look to find something that would say investigatory purpose not permissible under these circumstances?
It's, as far as I can tell, it very well may be an issue of first impression, because I could not find anything on point.
Here's what I'd like for you to address, and I don't know if this is going to come across weird, but I'm going to ask it, okay?
Okay.
So, witness testimony before grand jury is not discoverable. So if this is investigative, would it be witness testimony? Do you get my point?
If it is investigative in the sense that it was part of the grand jury utilizing their official capacity, then I think it would be entitled to the secrecy and shrouding. Does that answer your question?
Well, it makes me wonder, because if it's being used to investigate, to figure out what's what and who's who,
Right, I think that is their.
then, you know, is this a witness, or is this a potential witness? Is this as opposed to when you're at the grand jury, you've already completed the investigation, and you know the purpose and the role that everyone that's coming into the grand jury is going to be playing.
Right, and I think
You
that
know
could
whether
be.
they're a witness or not a witness, and if they're not a witness, you're not going to call them.
Right. And I think that could be, again, having to suss to get this together, having never been a prosecutor, that does appear to be one of the correct functions of the grand jury. But then we fall back on the prosecutor repeatedly saying they weren't even involved. This can't be part of their investigative power. They weren't involved by the prosecutor's repeated assertions. And then the other thing I saw, that when the grand jury, when you see case headings that are in grand jury investigation of XYZ, that's the only thing I could find that seems directly on point. It's often things like Medicaid fraud, maybe RICO. It doesn't look like they're brought in the same way that a police investigation goes along. Again, I'm just trying to figure this out. So I think they could be used in that way, but in this case, clearly they weren't.
And in other states where there is an investigative, whatever, that's treated the same? It's given the same
Actually,
secrecy and
so in a criminal procedure secondary source I found, it's funny, it said that actually the tendency in other states, because it was more of a statewide ALR type of a secondary source, and it said that actually the trend is getting more toward disclosure, more toward freeing this up. So there was a lot I highlighted in that and then didn't use in my brief because it wasn't on point of, oh, this would have been disclosable, especially if that person is going to end up being on the witness list for the prosecution, so they're going to be surrendering their anonymity anyway. So again, I didn't want to do too much crossing the other state boundaries because that doesn't bind this court, but it actually seems like other courts would have made this disclosable even more so than Ohio. And then the last point I wanted to make really quickly is that we're not just relying upon perceived inconsistencies. We're not trying to blow the roof off of grand jury materials and say they're all discoverable, you know, that the sky is falling argument. We're not doing that. We're saying that this motive to fabricate in this case, especially a case like this, where there's not a lot of evidence, there's no direct evidence implicating my client, that this is different than just saying that perceived inconsistencies. And I think the reason counsel grounded his arguments in in impeachment and testimony is because I think it is Greer. But at one point along the way, Ohio law did say impeachment was allowed. And then I think if you shepherdize that case, it wasn't overturned. And then case law has developed since saying mere impeachment is not enough for disclosure. And we would just maintain that Castile's statement, that's not the right, standard.
Well, but I think there's clearly case law that says impeachment is a proper basis for showing a particularized need, but I feel like from my understanding of the case law, you have to make a pretty high showing there.
It is.
Yeah.
It is. And that's, again, just to emphasize that it's not really a standard for Castile's statement anyway, and then for guns, we think this whole disturbing the basis of the charges at their genesis is big enough to show that the need is particularized. If there are no further questions, we would just ask that this court reverse and remand for a new trial.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. And that concludes our hearing for today.